Hello and welcome to week 5. Focus this week will be on contracts, specifically the area of breach of contract and remedies that are available to the harmed party. So, breach of contract. What is a breach of contract? Before we get into the discussion of breach of contract, the assumption is that there is a valid contract first. So, in any real life breach of contract legal case, the first thing you look at is, are the requirements of a valid contract met? So assuming that there is a valid contract, let's move forward. A breach of contract occurs whenever a party who entered into a contract fails to perform the promised obligations. Now, it doesn't matter if it's willful or if it's an act of nature, etc., etc. One of the two parties does not perform for whatever reason. Breach of contract cases, are they civil or criminal matters? Breach of contract cases are civil matters, which means they take place in a civil court, which essentially means that if I am found to be in violation of the terms of the contract or in breach, I can be sued and I might owe monetary damages, but I do not go to prison or jail. It is a civil matter. So a civil action looks like this. There's a plaintiff. The plaintiff is the person who alleges that the other side breached the contract. I'm the person who is going to argue that I suffered damages, typically monetary, financial damages, as a result of our other party's breach. I would hire an attorney. That attorney would draft a complaint, and that complaint would detail both the obligations that were breached, why I believe the other party's in breach, and the damages that I sustained as a result of that breach. That would suffice or constitute a prima facie civil case. On its face, does the complaint appear to allege a breach of contract allegation with damages being requested? The general goal in these breach of contract remedies is to place the party who is harmed in the same economic position that they would have been but for the breach. Okay? What that means is that the default remedy is typically a monetary or economic remedy. Monetary damages. Again, the goal in contract cases when there's a breach is to place the party that was harmed in the same position they would have been but for the breach of contract. Typically, you do that by calculating the damages and giving that person or that entity, corporation, a monetary award, which would be monetary damages. So, for example, if I agree to pay $50,000 to have my house painted, but I'm only willing to hand over $10,000 once the painting is complete, the court will award the painters $40,000 in damages. So let me go through a little bit more detail on that. The total contract price is $50,000 to have my home painted. Okay? The painter does the job, and now it's time to pay the painter. I only pay them $10,000. The painter sues me for breach of contract. They did the work, they fulfilled their obligations, and the court will look at the matter and say, we are going to make the painter whole. And in this case, whole would be the $50,000, which is the original agreed upon contractual price. Another doctrine associated with remedies would be the doctrine of reliance damages. And what this doctrine says is that we will award you monetary damages above and beyond the contractual agreed upon amount if it was reasonable that you acquired additional expenses in reliance upon the other party fulfilling the terms of the contract. The example here is that there's a contract for the construction of a pool, and in addition to in reliance upon the pool being constructed, I purchase lifeguard equipment because this pool is going into my hotel. And so let's just say that the agreed upon price for the pool is $200,000, and I spent another $10,000 on lifeguard equipment, etc. Normally, I would only be able to recover monetary damages in the amount of $200,000, but in reliance upon this contract being fulfilled, I spent an additional $10,000. And so that is the doctrine of reliance damages in action. The whole concept of reasonable reliance is based in this promissory estoppel. And what that means, it's a doctrine that says a party may recover on the basis of a promise made when the party's reliance on that promise was reasonable. And so that's where the courts are involved, because the courts will ask, was Professor G's reliance upon the terms of the contract reasonable? Now, different minds can come to different conclusions, but typically a judge or a jury, a trier of fact, will assume what would the average reasonable person find. Were Professor G's actions reasonable? There is a duty to mitigate damages in contract law. So if I allege that you defaulted on the contract, do I just sit back and let everything fall down and sue you for everything that I can? No. I have a duty to keep the damages to a minimum, okay? Specific performance. This is very rare. Most of the time in a breach of contract, there's going to be some type of monetary award. But what if the subject of the contract is a unique real estate property? Money's not going to help me because I need that specific parcel of property. Otherwise, I can do nothing with my business. So in that case, it's exceptional, but in that rare instance, a judge might say, or a jury might say, we are going to award specific performance, meaning we are going to force the defendant to turn that real estate over to the plaintiff, because that is the only way that I can be made whole. Liquidated damages. It's expensive and it's time consuming to calculate damages, prove damages, etc. So very often in a contract, the terms of the contract will detail what both parties are entitled to in the event that the other breaches the contract. And that's permissible. It's actually a good thing to do because it saves both sides a lot of money and a lot of time. However, courts will look at these on occasion and say, no, the terms of the liquidated damages are unconscionable because here's the scenario. I'm a small startup company. You're an established company. I really need your business. And you put in the terms of the contract terms that are so much in your favor in terms of damages that it's not even remotely fair. It's so obvious upon reading that it favors you in the event of breach. Even though you're the breaching party, you're the party that did something wrong here, didn't fulfill their obligations, but you still win, essentially. Now, why would somebody sign that contract? Either A, they didn't read it, or B, they're at such a discrepancy in terms of negotiating power, influence, and sometimes that happens. And courts will carve out that liquidated damages clause and essentially throw it out. But generally speaking, liquidated damages are a good thing to have because they prescribe what each party will be entitled to in the event of a breach of contract.